How do you defend against a protection order petition under Washington state's new laws? Hi, I'm Zachary C. Ashby at Pacific Northwest Family Law. Washington state put into effect a law that combined all protection orders into one and expanded the definition of activity that could be protected against. Great news for actual victims of violence, abuse, harassment, because now it doesn't matter the petition bring to the court. The judge has the grounds to grant your protection. That's wonderful that we were able to provide that protection. However, it's not wonderful for people who are falsely accused or who are the actual victims of the abuse, because the law is so broad that it's very difficult to defend against. Under the new law, you have to prove several things in order to defend against it. If the facts that are alleged are untrue or fictitious, then that's a good place, but you have to be able to prove it. You can prove it with witnesses who saw the events that are alleged. So you look at the dates and you look at the times that are alleged in the petition, and you gather statements and provide witnesses. The other part is, in order to get the protection request, all they have to do is show that there's some kind of a fear or concern that there's potential harm. Sometimes character witnesses will help, but not really, because it's very subjective. So proving that the person isn't really concerned about harm is really an important step to take. So you can look at subsequent activity, statements, and other things that would tend to indicate that the person has no fear or concern that they would be harmed by the alleged perpetrator's actions. Now, the other way to defend against this sort of thing is to show that the person alleging abuse is actually the abuser and turn the tables on them, filing a counterclaim that they're actually the perpetrator of abuse and abusing the system. You can do that by showing past activities, witnesses, some of the same things I mentioned before that would tend to show that the person accusing of the abuse is doing it. For example, a threat to say that, hey, if you don't give me full custody of the kids, or if you don't pay double or more in child support or give me money, I'm going to file a protection order against you and just take it anyway. That would tend to indicate that there's not really a fear, and that, in fact, the protection order should go the other way. And as an aside, that's why it's important to keep and preserve anything in writing, print it out, email it to yourself, preserve the full record. You get witnesses to listen to conversations so that they can testify about what was there. But those kind of things would show that there's not really a concern and that the protection order should be denied against a falsely accused victim. Some law firms have now decided to stop defending against domestic violence because it is such a difficult thing to defend against. We haven't. We just make sure our clients know ahead of time that it is very difficult, and we work closely with them to put forth the best defense possible. We've had some success there. If you have any comments, please comment below. Like the video on YouTube. Email us at info@pnwfamilylaw.com for more information, or just give us a call, 509-866-4842. Thank you.